3, 2, 1 and go. In other words, the jurisdiction of the High Court to decide the second appeal is confined only to the question framed by the High Court under subsection under bracket 4. The respondent, however, at the time of hearing of the appeal is given a right under subsection under bracket 5 to raise an objection that the question framed by the High Court under subsection under bracket 4 does not involve in the appeal. The reason for giving this right to the respondent for raising such objection at the time of hearing is because the High Court frames the question at the admission stage, which is prior to issuance of the notice of appeal to the respondent. In other words, the question is framed behind the back of the respondent and therefore subsection under bracket 5 enables him to raise such objection at the time of hearing that the question framed does not arise in the appeal. The proviso to subsection under bracket 5, however, also recognizes the power of the High Court to hear the appeal on any other substantial question of law which was not initially framed by the High Court under subsection under bracket 4. However, this power can be exercised by the High Court only after assigning the reasons for framing such additional question of law at the time of hearing the appeal. Keeping in view the scope and ambit of the powers of the High Court while deciding the second appeal, when we advert to the facts of the case, we find that the High Court committed an error in allowing the defendant's second appeal and further erred in dismissing the plaintiff's suit by answering the substantial question of law. This we say for more than one reason. First, mere perusal of the impugned order would go to show that the High Court had admitted the second appeal by framing only one substantial question of law, namely whether the first appellate court was justified in dismissing the defendant's first appeal by taking into consideration one earlier litigation in relation to the suit land which was not between the same parties. The High Court held that the first appellate court was not justified because the earlier litigation was not between the present plaintiffs and the defendants, but it was between the different parties, and therefore any decision rendered in such litigation would not operate as res judicata in the present litigation between the parties. This resulted in allowing of the appeal and dismissing the suit. The High Court, under bracket single judge, in our opinion, failed to see that even if the said question was answered in defendant's favor, yet the plaintiff's suit could not have been dismissed, much less in its entirety, unless the High Court had further examined the main issue of ownership of the plaintiffs over the suit land, which were decided by the two courts below in plaintiff's favor on merits. In other words, we are of the view that it was necessary for the High Court to have proceeded to examine the issue relating to the plaintiff's title over the suit land, which was decided by the two courts in plaintiff's favor, holding that the plaintiffs were able to prove their title over the suit land on the basis of documentary evidence, whereas the defendants failed to prove their title through asserted